Welcome back to Radio Entrepreneurs. My name again is Jeffrey Davis, and I'm the host of the show. And I feel really excited about this next interview. We're being hosted by the law firm of Tarlow Breed Hart Rodgers in downtown Boston. And my guest, someone I've known for many years, Stephen Kutenplon, a member and corporate counsel, correct?
Correct.
Welcome, Steve.
Thank you. Thank you. Pleasure to be here.
First timer on Radio Entrepreneurs. Why don't you tell our listeners first what the focus of your practice is?
I work with businesses and the individuals that start and own and invest in businesses, typically privately held, from the just 2 or 3 people or one person up to a couple hundred in size.
And you wanted to talk to us about a specific topic within the corporate world today, didn't you?
I did. I wanted to speak today about the so-called choice of legal entity that any new business faces as they're planning to start their operations. The typical spectrum of choices is a proprietorship, a association or loose partnership, a C corporation, an S corporation, or a limited liability company, an LLC. The first decision is typically whether or not the founders want a pass-through entity. That would be the choice of either an S corporation or an LLC if the answer to that is yes, or it would be a C corporation if a pass-through entity is not desired.
Now let's assume our listeners are not as educated as you are. You have to explain what you mean by, I know what you mean, but by a pass-through and a non-pass-through.
So a pass-through entity is one in which the income and losses of the business entity are reflected on the individual tax returns of the owners. That is what is known as a pass-through entity. A C corporation, on the other hand, is a separate non-pass-through entity. It files its own tax returns, whereas a pass-through entity files what are known as informational tax returns, and the owners of pass-through entities receive K-1s, which are a tax form which is used in the partnership world. And then if a owner, for instance, was a 10% owner of the entity and the entity made $100 of income in the taxable year, the 10% owner would receive a K-1 reflecting $10 of income, which she would have to report on her individual tax returns. Past the threshold question of whether to consider a pass-through entity or a non-pass-through entity is driven by a number of different factors.
Is there an advantage if you're going into business and have shareholders or partners in an S Corp versus a C Corp, or the other way around? Or is it all basically for tax purposes?
No, that's a very good question. There are some significant distinctions. The S corporation does have a qualifying requirement that there are not multiple classes of stock. There's one important exception to that is permitted with S corporations, and that is that you could have identical classes of stock, but one is non-voting and the other is voting. But that's not enough flexibility to entice, for instance, professional investors or even sophisticated angel type investors, because these types of investors often prefer that their equity capital go in as what is known as preferred stock.